This segment is our legal and legislative segment where we tell you what you need to know from the courts and from the legislators. Now, keep in mind, neither Mike or I are lawyers. We cannot give legal advice, but one of our sponsors of the show is, and that's John Dillon. John has been helping more and more people fight gun violence restraining orders, and those are gun violence restraining orders that are fairly new into the realm, and they're propping up. If you know somebody that's had their self-defense rights taken away without due process, give John a call. His website is dillonlawgp.com, and his phone number is 760-642-7150.
Okay, just a couple things to touch on this week. This is everything that I feel is important for you to touch on. I'm trying to be your one-stop shop so you don't have to listen for 20 minutes every time something happens in the legal world during the week, in the legal world during the week. You can just kind of go and get a general idea of what's going on. First is, this is good news. Linton versus Bonta, Linton, Linton versus Bonta. Bonta is, of course, our attorney general. So it's basically, this is a case against the state. The district court awarded the plaintiffs $244,399.76 in attorney's fees and costs, which, of course, California had to pay. So they won the case, and now the state has to pay. What is this case? If you hadn't heard of it, first off, Firearms Policy Coalition is the driving force behind it. There were some other plaintiffs as well, but a big thanks to Firearms Policy Coalition. We do not thank them enough. We cannot talk about them enough. They do such good work. So in summary, this is from FPC, lawsuit challenging California's laws and policies to deny Second Amendment rights to peaceable people whose rights should have been fully restored after their nonviolent felony convictions in other states were vacated and nullified. So these are people who had nonviolent felony convictions that had been removed, vacated and nullified. That's basically what that means. The lead plaintiff was a guy named Chad Linton. There were some others, and then Firearms Policy Coalition, Second Amendment Foundation, and California Gun Rights Foundation, and the Madison Society Foundation. So thank you all so much for acting on this. Such a great ruling. Yet another ruling saying, hey, the Second Amendment is not a second-class right. So they won it, and then California had to pony up and pay out the money. I don't know how that's all figured out, by the way. I don't know which plaintiff gets what. I guess they probably have some kind of formula saying, hey, here's who spent this percentage, et cetera. Okay, one of the other things I wanted to talk about, so that's the first one. Second thing you got to know is kind of ridiculous. They had an emergency session in the legislature up in Sacramento. It was an emergency. And basically it was a pony show, a dog and pony show for the governor, who's a jerk. And he wanted to Trump-proof California. So all that freedom and liberty and peace that you experienced for 4 years under Trump, well, the governor wants to make sure that none of that makes it to California. So we don't want any prosperity. We don't want any liberty. We don't want any peace here in California. We're going to Trump-proof the state. Great job, Newsom. So here's what came of it. And this was this is a bill that was introduced by State Senator Blake Spear, who's a local San Diegan and a blithering idiot. She's up there making sure that she does not respect your civil rights in any way. So she introduced SB 15. SB 15. Well, Mike, what does SB 15 do, you may ask? This is horrible. It's going to ruin our whole life. Let me just kind of read it to you. Existing law prohibits certain actions relating to the sale, possession, storage, and carrying of firearms. Existing law authorizes a court to issue a temporary gun violence restraining order prohibiting a person from possessing a firearm or ammunition if there is reasonable cause to believe that a person possesses a significant danger or harm to themselves or to another person by having a firearm. This bill, pay attention now, would state the intent of the legislature to enact legislation relating to gun violence prevention. Now, what did I just say?
This bill would state the intent.
So what is it going to do? Nothing. This bill is just a placeholder. They basically stated a bunch of facts. They said the sky is blue, water's wet, grass is green, and this bill eventually is going to infringe on your Second Amendment rights. Just wait and watch us go. That's all it is. It's just a placeholder. Now, this is rather than gut and amend, some bill, like, you know how they're like, well, XYZ bill was a farming bill, but now they want to ban your guns and take away your rights, so we're going to gut it and we're going to make it into an anti-gun bill. They got and amend it, and everybody gets all excited and says, hey, that's horrible and dishonest. Well, now they're being honest with us. Now they're just saying, hey, you know what? We just want a placeholder here. And once we figure out how to screw you, we'll let you know.
Then we'll describe it to you.
We'll describe it to you. You have to pass the bill in order to know what's in it. No, not quite. They're not going to be able to pass it unless it's actually written out. I was joking, but the idea is this is just a placeholder. So that's what Senator Blakespear is spending her important time doing, is just putting up bills that have absolutely no purpose or writing or anything. Okay, 2 arguments were heard. That's SB 15. 2 arguments were heard last week. I just wanted to bring to your attention. Not a whole lot to cover. I don't think we need to get down into the weeds. Rhodey versus Bonta, which is the ammo registration law, and then the U.S. versus Peterson, which has to do with the NFA. They raided him and found a solvent trap. Do you know about this solvent trap thing?
I do not.
So, do you know what a solvent trap looks like?
I can guess, but I honestly have no clue.
It looks a lot like a suppressor. And they basically say, hey, look, if you put the barrel of your rifle into this tube, and you can clean it, but then you can also use this thing as a suppressor, is really what it boils down to. Now, there might be some folks out there that are like, Mike, it's a solvent trap. How dare you? But the accusation is that they're using these solvent traps as suppressors. So it's not exactly a suppressor, but that's what he was busted with. So his defense, Peterson, against the U.S.'s accusations that the solvent trap they found is a suppressor, they're basically saying, okay, fine, if it's a suppressor, that would mean that the NFA bans it, but we think the NFA is unconstitutional. So they're kind of going after the whole Megillah, the entire whole thing. Now, what is the NFA? The NFA is the National Firearms Act. Now, the NFA was a big law that really, really, really was the kind of the skeleton. It was the guts and the skeleton of gun law. Before NFA, wasn't a lot going on as far as gun law goes, but the NFA said, all right, we need to set this up, and we need to make a bunch of rules, and we need to violate your rights in every possible way we can think of. So it regulated machine guns, short-barreled rifles, or SBRs. It regulated short-barrel shotguns. It regulated suppressors. And it was really, this whole act, they're saying, and specifically the part about suppressors, is a violation of your Second Amendment rights. That's the case they're making. Now, one other thing I wanted to point out is this guy Peterson. When it rains, it pours. They took his firearms and they threw the book at him. I just want people to be clear about this. When they, especially if you're an FFL, which he was, when they go after you, it opens the floodgates. So it's not just one violation. They went through all his paperwork. They found I's that he didn't cross and T's that he didn't dot on all this paperwork, and they are trying to nail him to the wall. Now, the crux of this whole thing is obviously this NFA claim. And they don't just do that to FFLs. They do that to everybody. So if you have one little tiny violation and the ATF finds out, they are after you big time. It is a big deal. And then the Seventh Circuit Court of Appeals, there's an assault weapons ban and a mag ban in basically southern Illinois, or it's Illinois. And it was ruled unconstitutional. So the Court of Appeals there stayed the decision, which basically a court said, hey, you know what? This assault weapons ban and this mag ban is unconstitutional. Now, this is not the Snopes case out of Maryland. This is Illinois. So this is probably not. So they basically said that decision that it's unconstitutional. We're putting that on hold. We're deciding that you need to you can still enforce it. You just need to just hold your horses, which is unfortunate. But I don't think this is going to get a lot of movement until after the Snopes case. Okay, so that's everything you need to know this week.
Okay, that's our legal and legislative segment.
Okay. Hey, thanks for watching. Don't forget to like, subscribe, and comment. And thanks for checking out Gun Owners Radio.